make a noise bit so that I'm... Sorry, that's for my recording, not for your making you nervous or anything. Okay, welcome back. Week 8. We're really getting to the business end now. I know people were tired because many of you had intro over the weekend. It's kind of a bit unrelenting now. That's why I said take a break. I want to start with a bit of a quiz to work out what you already know about capacity, so I can make a call about how much of capacity we talk about. So if you want to, in the usual way, take yourself to paulev.com/NolanLegal. For those of you who are listening at home online, I will make sure that there is a quiz that's very similar to this. So just do all of the quizzes before you listen to this. Like, stop now, go back, do a quiz, because you might find you don't need to waste your time listening to me. That's awesome. Of course, those of you who've done quizzes, you might just want to leave the room too, I get that, but now you're here. Okay, so contract that may bind parties, that should say but, will not be enforced by the courts is classified as. I need a proofreader. It's all right, many of you need proofreaders too. I'd do it if they paid me. That's part of what it is. It's me doing this in super fast mode. All right, I counted before. We've got 21 now, 22 of you in the room. That, by the way, is pretty much a record for me, that more than half of the face-to-face class by number is actually still in the room by week 8. I usually piss people off a lot sooner than this. So I've been the same person for the last 6 years. There's no participation, Mark, but it's good. It's good. I like having you here. It's so much better. Once I had a class with only 3 people in it, I had to ring them before class to see if they were even going to show up. It was like very sad. Okay, let's have a look at what you think. Oh, shall we show correct at the same time? That's usually part of the thing. Okay, so everybody was on the right track, but this is correct here. So it will not be enforced. That means it is unenforceable, using the language correctly. Those people who change their minds, we'll go from there. So similar but different question. If one party has the option to rescind a contract due to some defect, the contract will be classified as which of the following? Voidable, void, unenforceable, or illegal?
It's locked.
Oh, really? That's bloody annoying. Why is it locked, I wonder? Here we go. I'll do that so it pops up properly. Sorry about that. I've also forgotten how to turn existing questions into a competition. I was trying to do that while I was on the phone to somebody else today and didn't get there, so that's why it's just standard old survey mode. Okay. Few people are in there. Let's have a look. And again, so that I didn't really go on in relation to the last question because I had included this one. Understanding the difference between avoidable, unenforceable, and void contract is important. So let's unpick that here, although most of you are there. One party has an option to rescind. In other words, at their option, they can void the contract, which makes the contract itself voidable. If the contract is void, void means no contract. In fact, it's like a double negative. A void contract, it's actually no contract. There isn't a contract in the first place. And unenforceable, a void contract is unenforceable, but a voidable contract might actually be enforceable. Can anybody explain that to me? Why would a voidable contract, or when would a voidable contract be enforceable?
If the party who can void the contract chooses to keep the contract.
And for the money, Steve, if the party who has the option to void it wants to enforce it, it's voidable by one party, but it's enforceable against the other party. Make sense? So, and we'll talk about that particularly in the context of capacity. So, in capacity, capacity is not a formation element. So if a contract party suffers an incapacity, that doesn't mean there's no contract. There can be a valid contract made, but it cannot be enforced against that party. So that party may have the right to void it. So it might be voidable in the case of a contract where the miner has the requirement to ratify, for example, but they can still enforce it against the other party. So we'll look at some examples of that. So that's like a little bit of a head bend, I get it. Come on. And is it locked? Just check. No. Which of the following contracts do not bind a miner under common law? Oh, gee, I must have had this one in since I started using this program in 2012. They sent me a little thank you note saying I was one of their first users. I thought, oh, it's not like me to stick around with things for very long. It's time to get something else. Which of the following contracts do not bind a miner under common law? Supplying goods, employment, apprenticeship, or a supply of necessary services? More than one of them might be correct. Oops, sorry about that. We've got people in there. Oh, yep, lots of you have answered. Let's have a look. Okay, that was a tricky question. Supplies of necessary goods will not bind a miner, but the general class of supplying goods, sorry, I've said that around the wrong way. Supply of necessary goods will bind a miner, goods that are specified as necessary, but supply of goods generally may not. The employment, seriously not a stupid answer, because you might be justifying it or looking at it in terms of apprenticeship. Now, employment contracts that are beneficial contracts of service or beneficial contracts of employment will be binding on both the miner and the party who has employed them. Employment contracts, it just says employment contracts generally can bind miners, but again, there needs to be, it needs to be necessary. It needs to, it just can, as long as it's a necessary, we're okay. Supply of necessary services will definitely bind the miner. Miners will be bound to pay for services that are necessaries for them. And we'll talk about what necessaries are shortly. Okay, which of the following, might be more than one, does not have contractual capacity? Just making sure it's not locked. A mentally incapacitated person, a 15-year-old, a prisoner, a married woman, an intoxicated adult, an elderly homeless person. One or more of these. Sorry? It won't let you select more than one. Well, you'll be right. Nobody's counting the scores. You'll be right unless you select the wrong one, right? So make a note. Just relax. All right, let's have a look. A few of you are in there, I hope. Oh, yes, quite a few. Let's have a look. Oh, sorry. Unlock. There we go. So basically, the only ones that were not covered there, so there's 3 right, 3 wrong. Prisoners, it used to be the case that a prisoner can't be held to have capacity, but that is no longer the case. the rationale was that they lost sets of rights. So they had a set of rights that once they were incarcerated, they no longer had. Technically now, a person who is being held without release, in theory, cannot be bound to a contract, but it's never been tested. So your textbook talks about it. I think part of the logic is as well that idea that, well, in prison you shouldn't actually have any contracts that you would be entering into because you're in prison. And so prisoners very rarely sue in contractual matters. But yeah, that's the logic. Rights are taken away from you, including those rights. I'm glad nobody put the elderly homeless person in there. I was looking for bias. And I'm very glad nobody put married women in there. But to the extent you were thinking, oh, I wish I could have put that one in there, I'm very glad you didn't, because I don't want to get cross with you. But that, sadly, was the case for quite a long time. Okay, can a minor recover money that the minor has actually paid for non-necessaries? 3 options. Yes, the contract isn't binding, so the seller has to repay. So that's repay money that they've got from the minor. No, neither money or goods can ever be recovered from the other party if a contract is void. Or the third one, only if there has been a total failure of consideration, but otherwise as a general rule, no. Oh, and I didn't clear the results from last time, so it will now have got to my max at a guess. So, unfortunately, I clearly don't explain this part very well in my videos, or you don't watch them, one or the other. So, total failure of consideration. At the end of the day, oh no, actually, that is wrong. That's why it's there. I haven't fixed it. No, the actual answer, the majority of you are absolutely correct. Sorry, have I thrown you? No. I'm sorry. I don't know. Like I said, I need a proofreader.
I was like, I have this one right as well.
Oh no. Okay, that was just a little act of kindness. The majority here is right. A contract isn't binding, and so the seller has to repay. So it's voidable by the minor or the minor's guardian. So if a minor goes and buys stuff, then they can undo it. Now, if the stuff has been consumed or turned into something else or broken, then there might be a different consequence. So if it's been turned into something else, if it can't be returned, if it's been eaten or dealt with in some other way, then you might have an issue getting the money back. Also, it is worth remembering that even though you can get the money back if a minor can get the money back for goods or services that were non-necessaries, if somebody lends a minor money to pay for non-necessaries, they won't necessarily get the money back. The loan is different. A loan will be treated differently from the goods or the services themselves. Okay, let's do a problem task here. Tom, who's 16, travels between work and home by bike. There's no available public transport. He bought a new bike from John, giving John his old bike as part payment. Tom now doesn't want to go through with the deal and pay John the remaining money. Something's gone wrong with my cut and paste as I threw that in. Can Tom avoid the contract? Tom is our 16-year-old. Actually, it mustn't be that. It must be, can John enforce the contract? Can John? Sorry, can John enforce the contract? Just looking at the first option doesn't make sense if it's can Tom avoid. So, but then again, I'm historically quite good at giving you questions that don't make sense. I said to somebody today that the difference between a good lawyer and a bad one is not knowing the answer, it's knowing what questions to ask. I'm just giving you many opportunities to question me and get into that habit by putting stuff like that here. All right, few of you are in there. Show results. Okay, vast majority in the same place. So the bike is a necessary. Did this remind you of one of the cases? Can you remember what it's called? No, neither can I. That's why I'm asking you. Is it the Sturzacre one? Yeah, Sturzacre or something. There's two with Polish names. So anyway, the Sturzacre case is the name of it. It'll come up on the slides in a minute. But effectively, there was actually a different outcome in that case. Can you remember why, Sarisha? Yeah, it was a different outcome. They were similar facts. But in that bike case, so in the case I'm talking about, there was a kid who had, oh no, sorry, it was the same outcome. Sorry, it's exactly the same outcome. I've done it the wrong way around. So he had a bike, he traded his bike in to get a new one and then refused to pay for the new bike. He then argued successfully, unsuccessfully, he didn't have to pay because he didn't need a better bike. But it turned out that because he had given away his old bike, he no longer had a bike. The bike itself was necessary to get him to work. Didn't matter whether it was a better or a worse bike. He didn't have any other bike. If he had just paid a deposit and kept his old bike and handed over and taken receipt of the better bike, the result would have been different. But he still would have had to have returned the bike. He would have gone back to the position that they would have been in. I can tell I'm just not having a good day. I'm not on it today. Start your complaining now. A common law, mentally ill and intoxicated people are treated essentially the same way as minors, subject to two qualifications. They must have been incapable of understanding the nature of what they were agreeing to at the time they entered into a contract, and the other party must have been or should have been aware of their condition and the consequent incapacity. In order for a contract with such incapacitated person to be voidable. Locked out. I can't say the word incapacitated. It's going to be one of those days, I can tell. We'll unlock. I might take a seat. Oh, answers flying out. There was 22 and it's gone down to 18, 19. Here we go. Show results. Yes. So it is true. Minors, it doesn't matter whether a minor can understand the contract or not. It doesn't matter with a minor whether or not the person dealing with them knows that they're a minor or not. What matters is that they are they have not achieved their majority, is the language that the law uses. They haven't achieved their majority. Where in relation to other forms of incapacity, there needs to be a lack of understanding on one side and the ability to be aware, or at least it would be a reasonable person would have been aware that somebody was suffering an incapacity. Ken?
The second point of that, what's the significance in it? So if one person doesn't have the ability to understand, why does it matter if the other person should have known that this person can't understand?
Because that's effectively, it's a punishment. It's putting the onus on the shopkeeper or the contracting party to not take advantage of somebody. So if you can't tell whether somebody has dementia or lacks understanding, with minors, you get to ask them for ID. You can't. Can you imagine a world where we ask people every time they bought something, can you breathalyse here? Can I scrape your tongue? Could you please do this small survey so I can determine whether you're suicidal or not? I'm suspecting that would be an outrageous impost in the broader sense. But it does circle back to the other question, though, of how many 15, 14, 13, 12-year-olds do you know who are quite capable of understanding that if you order fast food and you need to pay for it, if you go to McDonald's you need to pay for it, or you buy a movie ticket, that you have to pay for it, or if you purchase apps on a phone, somebody needs to pay for it. There's a capacity. There's no doubt in my mind that most children significantly younger understand the basics of what it means to contract, and there'll be 20-year-olds, 30-year-olds and my darling 85-year-old father who will never understand.
So that makes me wonder, and I've forgotten the term for it, those electronic contracts you click and accept. If a minor,
Electronic contracts they are, yeah.
Technical term. If a minor, an 8-year-old clicks, yes, I'm over 13, 16, 18, whatever, what happens there? Because if an 8-year-old says, yes, I'm over 18 and goes to wherever he's going and he buys whatever he buys.
So there's a couple of different things that go on there. So usually with an online transaction, the method of payment is some kind of credit or debit account, which you need the authority of a person who has capacity with the bank to operate that kind of account, to have the account in the first place. So usually what happens is, particularly on devices, the platform, so the platform through which you purchase, the account will be held in the name of an adult. And so the virtual click is by the child as the agent of the adult. Now, there's been a lot of consumer stuff about that. In fact, that was pretty much the critical analysis problem in last semester's exam, was around what the issues were or might be with capacity and whether it was a fit-for-purpose test, and what else needed to be done, if anything, to deal with children contracting online. But when you actually unpick where the contracts are, the contracting party is usually the adult. There are some that are odd though, like Facebook, for example, internationally requires you to put in a date of birth that shows that you're 13 or older. So I think my son, who's now 20, started his Facebook account when he was about 11. And so he's like 2 years older on Facebook, as are all of his mates, which is possibly not a bad thing from the point of view of identity theft. But yeah, good question. I think that's all I want to do in relation to that. Any questions, concerns, frustrations?